So this is great. This is the largest group we've had so far. Thank you all for coming. I'm Fritz, and welcome to the Senior Empowerment Series. We've been doing this actually since February. I don't know if, and trying to get the word out. So I am with Keller Williams, a real estate broker, and also a senior planner. And we have a community at Keller Williams called Keller Williams Planner, Real Estate Planners. And so we help people avoid capital gains tax and avoid family disputes and that kind of thing. So, anybody have that? Have you had? You don't have to raise your hand. And then, so as we start here, how many people have a will? Just like, how many people have a trust? Okay, so yeah, so we'll be talking about legal affairs. Who believes they have everything in order? Oh, okay. Where's that? Hi, Jen. Welcome. That's okay. So this is an important topic for us because in our real estate business, a lot of people end up not having everything in order. As you can imagine, there's examples. We had a client who is named executor in a will, and they said, okay, I want you to sell the house. My dad's house needs to be sold. And I was like, do you have a will? You have a will, but do you have a trust? And she said, no, we don't have a trust. Oh, well, you're going to have to go through probate. It's not going to happen so fast, and there's going to be some time going by. And they unfortunately had to cover for the mortgage until the probate thing was finished. So there's a lot of things that can happen, and we're going to try and address as many of those. And we'll leave, please, on the first page of your handout, you'll see there's a place for notes. So we'll probably do 50 or so minutes. I'll be asking some questions, and then you're welcome to write down questions you might have at the end, and we can address that too. We'll have about half an hour, maybe a little more for question and answers. So, yes?
Is that the handout related?
Oh, here's the handout. Anybody else need a handout? There's about 3 more.
Thank you.
I agree with you. And at the end,
3 in the front are
Oh, good. I'm
And
ready.
then-
No, we're short Not everybody.
and so at the end, I'll ask you to fill out the evaluation. There's an evaluation on the back side of the handout, so you can rip that off. And as you go, if you know, and before you leave, you can give that to us. And so, without further ado, let me have the guests come up. We have Lisa Cosper from Sutton Thayer Brown, and we have John Atwood from Cardinal Trust. And Mike, here, have a seat. This is the first time we've used microphones. I thought, here we go. I don't know if we'll try the without the microphones at first, and if anybody has any issues with hearing, we can use them. How's that sound? Does that sound okay?
Let's see what it says.
The thing is, here in this room, unfortunately, the air conditioner is a little bit loud, so if our voice is carried. Not really, no, we can't. It's locked right there, see?
If you can pick the lock.
So, can everybody hear? Shall we you want to just use the microphone right out the back? No?
We'll just try to talk
Right.
loud.
Okay, we'll try to talk. Okay, because we have to talk over the cooling system. So, I'll have our guests introduce themselves, what their specialties are, and what they actually do a little bit, and then we'll go into the questions. So, Lisa?
Hi, I'm Lisa. I'm a estate planning attorney with Sutton Thayer and Brown. I specialize in just estate plans, probates, uncontested probates, trust administration. I am not a litigator, so I try to do everything in my power to make sure I've got a complete plan and head off problems as far as we can foresee. I don't have a crystal ball, so I can't tell you exactly what's going to happen when you pass away, but I can try to advise you the best I can to make sure you've got all the proper documents in place, we've addressed all of your concerns, and we have an open communication to make sure we can try the best we can to avoid any potential issues after you've passed away. Unfortunately, we are a very adversarial society and people get upset about things, so if we can try to head off those and preserve your estate the best we can, that's what my goal is. But unfortunately, if there are litigated issues, our firm does have a litigation wing as well.
Great. I heard a joke that elder law is what happens when you stop breathing, right? And that's what you're preparing for when you stop breathing. But I just heard a joke that said elder law is actually when you stop breathing on time. Okay, sorry. John, go ahead.
Did you get that from Clarence? Is that a joke?
Could have.
I'm not claiming that.
Okay. Well, thank you very much for joining us today. When Fritz asked you how many people have an estate plan, you beat the odds, and so that's actually, if I may, I'd like to give out 3 prizes for estate planning trivia. Is what I'm calling it. So, what percentage of people in the United States do you think would have an estate plan already in place? What's the percentage? And just
30%.
30%,
10%.
25%. Oh, I'm going to need some math here.
10.
17%, 10,
34.
34.
40.
30.
40.
Okay, stop, please. I've only got 3 prizes. Who? I know you said 34%. Then somebody over here, one of the troublemakers in the front. 30. 33%. 33%. Look at that. 33%. That's you all. I mean, there's a couple of reasons I asked that question is because let's not feel guilty if we don't have a plan. There's no 3 out of 10 have a plan. So majority of people don't have a plan. So feel okay about that. That's one of the reasons you're here, is to find out a little bit more about all this planning. So how much money should I have to create an estate plan? How much money should a person have to create an estate plan?
1,000?
How much?
1,000?
1,000, okay? How much? No idea. You have no idea, okay? $1. I hear $1. Okay. Get into an auction here. 1,000, $1, 500. I'm kind of getting a feel that you don't think you have to be rich to have an estate plan. That's right. That's right. So the answer is, what's the answer? How much money should I have to create an estate plan? Lisa?
Well, I'm going to pose it a little bit different.
Oh,
Does
okay.
anybody have anyone or anything they care about? Yes. Because if you care about somebody and you don't want to leave them a mess, or you're like me and you have 8 dogs and you want them to make sure that they're loved and cared for, if you care about anyone or anything, you should have a plan in place.
Okay,
I like that.
I'm going to give the prize to the person that said $1. Okay, there you go. That's not coming the longest distance. Okay, good. Okay, one more trivia question. They're not really trivial, are they? They're kind of important. How old should I be to create an estate plan? How old do I have to be to do that? What's kind of that age where I need
65
to
when you retire.
55.
65.
65.
When
When
you retire.
you retire, that's
That's
kind
how you
of
think
the sweet spot.
Yes.
Okay. Have to be alive is another one. That's helpful. Yes, alive, or what's the other kind of trick to creating an estate plan other than being alive?
3 days.
Breathing is good. Yes, it kind of sort of dovetails into that.
Being in your right mind.
Oh, who said that?
Oh, there's
Okay, I'm gonna give it.
Chocolate.
Wait, that's 2. Oh, Mark, you can share. You can share. Okay, being in your right mind. That's kind of important, isn't it? And maybe Lisa will tell us what does that really mean, because it kind of it's a more complicated question than we think it is. Being in our right mind to create a will, or to create a trust, or to we'll get into that. So I'm John Atwood. My brochures and cards and everything are over here. I've got with me my COO that's keeping an eye on me today back in the back, Wave Kim Finley. Kim is from Oklahoma. So if you're from Oklahoma or you like Oklahoma, you can talk to her about that. I'm from Kansas originally. I left there a long time ago and never went back. It's a wonderful place to grow up, but I just I don't see any of these like mountain things there that kind of attract me. If you want one of these, it's not a breath freshener, it's actually a hand sanitizer, so be careful there. And then, so I've been involved in the trust and estate administration business for about 15 years. So I take Lisa's documents and other estate planning attorneys. Marcos is here from Sutton. Marcos, thank you for joining us. He calls himself a baby attorney. I don't really agree with that. He was involved in financial planning for many years, and he serves on the New Mexico Estate Planning Council, which helps with a lot of estate planning type seminars and things for people that are wanting to learn more about estate planning. So thank you, Marcos, for being here. So about 15 years I've been doing this, and I'm sorry, but I probably should sit down. I feel more like I'm in the movies or waiting for my shot to come up. My mother was a trust officer for 20 years and actually talked me into doing this late in life. I was working for an engineering firm up in Seattle. My father passed away here in Albuquerque, and I came down to help take care of my mom. I had been such a horrible teenager that it was time for me to pay mom back for all the bad things I had done, all the jail time. I never served jail time, but or even get close. I thought I was too attractive to actually go to jail, so I stayed out for that reason. So all that is supposed to be a joke. So I take Lisa's plans that she's worked out with you all, and I, at the point of, in your plan, correct me if I'm wrong, the two kind of opportunities for me are if you're unable or unwilling to serve in the capacity and the legal role that I would play. So I am currently involved in financial power of attorney backup role. So if you're married, generally, you name your spouse as the backup to you to make medical decisions for you. If your spouse has passed away and you're alone, and you may name a friend or family member or somebody. So I'm involved in that work in terms of carrying out the financial decisions for you, your real property, your trust. If we're in a backup role as a successor trustee for you, and then there are other roles that I play that we'll talk about here in just a little bit. So anything sort of financial after you're unable or unwilling to take care of those matters, there is a corporate solution for you that have trust officers like me, money managers that are in our firm, and those types of folks that assume that role. But we let the legal estate planning documents rest with the estate planning attorney. You two work out those details, and Lisa comes up with the package for you, and then if something were to happen to you, then we're the folks that you may put in your document as a backup for you. So been doing that 15 years. I love it. It's a passion of mine. So that's one of the reasons I think I'm here.
That's why you're here. And also, you also take care of people who have named people in the trust that are unable to take care of their affairs, even if they're alive. So
That is correct. That's
there's
right.
a couple of, I can't remember the names of
They're
beneficiaries.
beneficiaries
Yeah.
of a trust or of a will, the devotees or the beneficiaries from your will then we make sure as personal representative, the role, most of us, when I say personal representative, we tend to get that blank look. It's what used to be called an executor or executress, but the wonderful folks up in Santa Fe several years ago changed that to be, I think, one of the reasons was to be a little more gender neutral and less confusing. So personal representative is what we use now legally as the person that handles your estate at your passing. And so we take care of that area, and then we serve as a trustee to settle your estate, or if your trust or will says, I would like to leave money in trust for my son or daughter that has an addiction or mental illness and can't take care of their own financial matters, then we stay on as trustee, or we become trustee to handle their financial matters.
Perfect. Yeah, that's what.
You know.
So, in terms of estate planning, what are the essential documents we need to have?
Yeah, so everybody should have,
And when should you not have a will, and when should you have a trust?
okay, yeah. So, general foundational documents, if you have a trust, should include the trust document, a pour-over will. This is a safety net, so if you don't get everything inside the trust, this pours it into the trust. You should have a financial power of attorney, healthcare power of attorney, and advance directive. You should have a HIPAA disclosure, and then also, if you want to be cremated, a cremation authorization form. Will packages are similar, everything included except for the trust. So you would have your will, healthcare power of attorney, advance directive, HIPAA disclosure, financial power of attorney, cremation authorization form. Some instances where you might want to have a trust over a will, like John mentioned, wills go through probate. So a will alone is not enough to avoid probate. Wills are instructions to probate judges to tell the judge who you want to be in charge and where you want your stuff to go, but nobody is appointed until a judge appoints the personal representative through the probate process. So if you're interested in avoiding probate, a trust, a fully funded trust can help accomplish that goal. Sometimes if there are concerns about people who would be entitled to notice under a probate, so hypothetically speaking, you have 3 children and you're leaving everything to 2 of the children and not the other. As heirs at law, they would be entitled to notice of the probate, which can cause issues with litigation and probate, whereas trusts are administered privately and only the qualified people entitled to receive information about the trust receive information. So if privacy is a concern. If you have beneficiaries who may not always be able to handle their affairs, like John alluded to, maybe there's beneficiaries with substance abuse problems. Maybe they're not financially mature enough to handle their distribution. For example, I have 2 little kids. I'm not leaving them any money outright. 2-year-olds and 1-year-olds, I can't name them. So, you know, a trust is a more viable option. Or if you are trying to avoid the court process in general, you want to avoid a conservatorship, a living probate, a guardianship, maybe those are also scenarios where a trust is more appropriate.
And that's not a bad topic for some time down the road, guardianship, and this is throwing out my suggestion, guardianships and conservatorships. The Journal has done some, maybe some of you have read some of those articles a year, 2 years, 3 years ago about the evils of guardians. There's some truth to what was said in the Journal, and there's some kind of where we want to sell. Anybody here work for the Journal, Albuquerque Journal? It's a wonderful paper. I love it. They're hanging on despite the internet and all that. So I don't want to disparage them, but they're sort of like television shows, and you've got to produce revenue to stay in business. So some of the articles, shocker, some of the articles you read, just because it's in a newspaper, we all know, don't believe a lot you read on the internet, but sometimes there are articles that are spiced up a little bit so that you are more interested in reading them. So again, the articles on guardians, professional guardians. There's some elements of truth in some of those articles, but there's also another side to that story. And I know professional guardians, we have a sister company that does this kind of work. So at some point it might be an interesting topic for people to know, what's all this guardianship and conservatorship
Well,
stuff about?
I think we can talk about that, because when you actually set up a will or a trust and you set up a guardianship, is that where that starts? Or is that more the court would appoint that, or who actually sets up the guardianship status, or finding a company that does it, and somebody has to find the company, and there's a bunch of pieces to that.
Usually, in my experience, a conservatorship or a guardianship is a result of not planning. So you don't have a financial power of attorney or a healthcare power of attorney in place to nominate somebody to speak on your behalf when you're unable or unwilling to make those decisions. So conservator is guardian of your affairs, like your money, your tangible stuff. Guardian is, so you got your court conservator, or you got your guardian of your person, so person making your healthcare and healthcare decision making.
Where you live.
Where you live, what kind of care you're giving, are you living in an assisted living facility, memory care unit, are you at home with home care, all of those types of decisions. And if you don't plan, is usually when the courts get involved to say who's going to be that court appointed guardian or conservator. Or you haven't planned well and there's a dispute as far as who should be your nominated conservator or guardian. Unfortunately, we had a case where the plan only provided for the spouses, and spouses nominated each other, and there was no backup. So when they came in, unfortunately, both spouses were incapacitated. Husband was trying to take care of wife, but he was very rapidly losing his ability to care for himself. Children who did not get along, did not think that either parent should be taking care of each other, and there were some ill will and feelings towards the siblings and who should
Magic.
be
Good power.
appointed. And so just poor planning led to a court process that untangled.
That Lisa's good point. We don't think about that often. Always have, there's a lot of good estate planning attorneys in Albuquerque. A lot of them. Well, there's a handful of what I would say are really good estate planning attorneys. I'm sitting next to one. The Sutton firm has been involved in very high quality estate planning for many years. I've been doing this 15 and I've always worked with Sutton. But that is a very important issue, is make sure if you don't have Sutton, if you have somebody else that's preparing your documents, always have a backup to you and your spouse, or you and even a friend or a family member. Have a third backup, because something can happen to your backup. And I know I interview a lot of folks, and they'll say, I have my sister, but my sister's older than I am as my backup. So you want to, it's great, have your sister, she knows you better than anybody. I am biased, I will admit that at all times, because I see instances where we are appointed by the court when there isn't a backup. And so if you have a corporate fiduciary, I call it, we can talk about what the heck does that word mean. If you have a corporate fiduciary or a corporate healthcare power of attorney, some company, an entity that has employees and has continuity in their operation, they have a bench. Sorry for the football. My Chiefs won last night, so I'm on a high. But they have a bench people sit on. And the more players, I think they've got 50-some that can be on their team. So a corporate entity has a bench of people that have experience and training and oversight, either with us by a regulatory authority. The New Mexico Financial Institutions Division looks over our shoulder. We have insurance, loads of insurance, millions of dollars of insurance. So there are protections sort of embedded in a corporate fiduciary in our instance. So it doesn't have to be Cardinal, it could be somebody else. It could be your bank. Let me throw this out. My full transparency, my wife is a trust officer at New Mexico Bank and Trust. I met her in the business, and she's a wonderful, lovely person. Hi, Irene, if you check this on the video. So banks are fine; they're fantastic as a trustee. Or some banks will not be financial power of attorney. Some banks will only want. Or I was meeting with an investment advisor from Merrill Lynch the other day. Came in, and actually we were talking about her plan, and I asked the dumb question. I said, well, you're a financial advisor for this large investment firm. Why are you talking to me about Cardinal Trust serving as your trustee? And she said, well, there's one basic reason. My company, maybe I shouldn't have given out the name of the company. My company will take my liquid assets, my investment accounts, and I said, of course they would want to serve as trustee for your liquid assets, your investments. But she said, my mother and I, and this is really, her mother was with her, my mother and I own condominiums, we own two commercial businesses, we have oil and gas leases, we have, thank goodness she didn't say timeshare. That's one of those fun ones for us to deal with. But they would, all they wanted the gravy, they wanted the steak without anyway, they didn't want the risk involved in these other things. And their desire was to hang on after they passed away, hang on to these revenue generating properties and so
The low-hanging fruit.
yeah. And I said, we're okay with that. We do that. And she said, well, that's really, I was hoping you would say that because that's why we're here. And just to tack on real quick, so we are somewhat of a unique trust company. If you go to my wife's bank, again, hi honey, they will ask if your investments are at a specific advisor at UBS or some other investment firm. They will very politely say goodbye to your investment advisor that you've had many years of a relationship with, and they will bring the money in-house. They'll bring it into their own investment. So if you're okay with that, then that's okay. But if you want somebody that hangs on to your trusted investment advisor, Cardinal Trust and a handful of other trust companies in New Mexico, actually we welcome, and that's our model, we welcome your investment advisor to continue to serve after you pass away, and your trust establishes a trust for your children or grandchildren. We keep that investment advisor. We hang on to your CPA if you have a CPA that you trust. If you trust them, we trust them. Now, we don't just ignore what they're doing, we keep an eye on what they do, just like you do. So we have a duty to do that according to the Uniform Trust Code. We operate under many laws, and if you're a private trustee, if you're a family trustee, you're not exempt from knowing, understanding, and operating under the Uniform Trust Code of New Mexico or the Uniform Probate Code if you're a personal representative. You're not exempt from that. The judge, if something goes awry in the administration of your estate, there are family and friends that might turn on your selected person. It doesn't happen often, but it happens. And so a fiduciary, I have an illustration in my slide presentations about two deer that are standing in the woods. It's an old Gary Larson cartoon, and they're drinking coffee, standing up on their hind feet in the woods, and one of them looks over at the other deer. Oh, I thought it would work. It did work again. You have a trick? So the two, that's what it is. He looks over at the other deer, and some of you have seen this cartoon, and there's a big target, a circle with circles and circles, and it's actually a target. And the guy the deer that doesn't have the target on him says, "Bummer of a birthmark, Hal. You're a deer, you don't want a birthmark target." So I mentioned that in a humorous way because when you select the person or entity that will serve as your that carries out your estate plan after you're unable or unwilling, that person has a target on them because they have to follow the statutes of the state of New Mexico as it relates to whatever plan they're carrying out, whatever role they play.
So I got a question on that. So you put a trust in effect, and there is some person, entity that has to see it's carried out according to what you put down. So what's the fee that they normally charge to administer a trust?
Good question. I like to save that to the very end, but like a car salesman, they don't want you to know anyway. With us, it's pretty similar. We have to, the statute basically says you can charge reasonable compensation. So there's not a number that the state of New Mexico puts on me to serve as a corporate trustee. I have to be reasonable. That's the terms that's used. So what is reasonable? My interpretation, a fee that will not be challenged by someone. Or if it is challenged, I can walk into court, stand before a judge and say, Your Honor, I do my research and this trust company charges this trust company charges this company charges that. So we're in line with what they charge. So specifically for Cardinal Trust, if it's under $500,000, if we're involved in your estate as a trustee, $500,000 and below, we charge an hourly rate to handle your estate and handle your, if you leave $400,000 to your son because he has a gambling addiction or something. I'm throwing these illustrations out there, could be anything. He just doesn't handle money well. Your daughter doesn't handle money well. They have a husband that, this is a kind of an important point. If they have a spouse that you are sort of concerned about, that if I give $500,000 to my daughter, there's something about that guy I don't trust. If that's the case, then you discuss that with Lisa and you figure out when there's this iffy sort of situation, if something happens to me, let's talk about it and figure out what's the best thing to do. So we're $500,000 and below, it's hourly with a minimum of $200 a month. If it's $500,000 to $3 million, then we charge 1% of the current market value of the assets that are in the trust. So it's 1%, $500,000 to $3 million. The more you have, the less percentage it is. It's tiered so that the more money you have, the less expensive it is for your trust.
What are some average hourly rates that you've seen?
Average hourly rate probably, because my rate is $150 an hour, but I don't do everything, nor do I want to do everything because it gets expensive. So I have my trust assistant, or if it's a clerical item, paying a bill, then that's even less. So probably the average, Kim, what would you say would be the average hourly rate within $500,000 or under trust?
So yeah, we have our trust, our higher end is like 150, I think our bookkeeping is 95, so and then we have the trust assistant rate of 125.
Right.
So you're, depending on what's being done.
Yeah, and usually when we step in, we spend a lot more time because we've got to, what I call, marshal the assets. We have to figure out what is it you own out there. And if we've met with you earlier, and I do this a lot, I meet with people that are thinking about having a trustee. Lisa may refer somebody to me, or another estate planning attorney, or an investment advisor, and we discuss some of these things so that you have a good idea of how much it's going to, fairly good idea of how much it's going to cost, and we have a fairly good idea of how complex your estate is. I hear a lot when I interview folks. I have a very simple estate. after 15 years, I don't buy that anymore. And I'll tell you why, real quick. I don't want to dominate this, Lisa.
Too late.
Weird little things pop up that you may not even remember, or there may be somebody that challenges something. Now, we have this trick in the state of New Mexico. Lisa can put in, I'd like your opinion on this. If you challenge this plan, you get $1. So does that run all those people off from challenging the plan?
Not always.
Not always. So it's
But
usually,
usually,
Yeah, there's creative ways that you can include what's called a no contest provision. Some are not drafted as creatively as most people would think. They have a general no contest saying if you challenge who's appointed or the validity of the document. But you can expand upon that no contest clause to include a variety of different things, not only who you've appointed, the way that they administer the estate, who's getting what in the testamentary document. You know, if you've itemized certain personal property to go a certain way, or certain accounts, or certain division of the assets. Not only just the validity of the document, but the actual administration. They can be created very well to encumber a lot of different potential scenarios for the no contest. A lot of misconception with the no contest is, oh, I've got a beneficiary or an heir that I know is going to be a problem, so I'm going to leave them $1 in my will or my trust. That creates a whole other set of problems, because now you've incorporated them as a beneficiary and you've expanded their rights to what information that they're entitled to. Whereas if you just completely acknowledge them but exclude them, or maybe you do want to provide, maybe let's say, I'll use my siblings for an example. I've got, one full sister, 2 half siblings on my mom's side, and a half brother on my dad's side. My brother, growing up, has had some challenges because he is the baby and caused a lot of problems when he turned 18 and, caused my mom a lot of heartache. Let's say hypothetically my mom says, okay, I still love him, I want to provide for him, but I'm only going to leave him $20,000 because I've given him a lot throughout his lifetime, so I want my girls to get more. And these are all the type of things my mom loves it the most.
Who's the baby? I am too.
So let's say hypothetically she says, I'm going to give you $20,000, but she includes a no contest provision saying if you contest the validity, you contest the distributions, you contest who's appointed, you contest the administration, you get 0. So for some people, they are not willing to lose that $20,000. They'll just sit tight, wait for their money, and go away. Some other people, they'll say, no, I think I can get this whole bucket, so I'm going to challenge. And because things are adversarial in nature, then it gets contested, and there's a whole separate set of rules when it comes to litigation. But we can try to head off a lot of those issues with appropriate no contest provisions in a document. They just need to be crafted to your particular circumstance.
and if it's low enough, there's no reason not to contest it.
Correct. And so if you say I'm going to give you $1, well, if I can get $1 million, why am I worried about losing $1?
Yeah, I'll go find somebody that can challenge this. Can I add, this raises a really good point. We all are getting used to the internet, most of us. My mom didn't like it after she retired. My dad loved it. So I saw the lover of the internet and the hater of the internet over here with my mom and dad. There is a movement, and it's becoming more and more popular, to go on the internet, and why do I have to pay Lisa when I can pull it off the internet? Right?
NOLO, something like
NOLO. There's 10.
that. Yeah.
Why should I have Lisa or somebody that's a qualified estate planning attorney do my plan versus getting it cheaper off the internet?
It's a great question, John, because an internet search can give you a whole bunch of different answers, but can't give you something that's tailored to your specific information. And it also just gives you a flood of information that may not always be accurate. So a lot of times when people come to see me, they've already done their Google search or their JD degree by the internet. It's not always accurate. So they say, well, I'm worried about Medicaid recovery and planning, and they say, okay, I want an irrevocable trust. And and they don't know all the terms that come with an irrevocable trust, that it's giving away your assets. You no longer have control over things. And when we break it down and explain why what they found on the internet may not be applicable to their situation, that's where you're getting your benefit. You're getting customized, tailored legal advice to your specific needs, not just here's all the general information that's available. And it's always, it can also not be state specific. There's different state rules, there's different local rules. It may not address all of your questions or your concerns. You may get a fillable PDF that says, okay, here's a statutory will that conforms with the New Mexico probate code, but it doesn't address all of your questions. Like, for example, John mentioned, well, what if we've got concerns about a child's spouse? I have a crazy Aunt Molly that is everybody's child's worst nightmare. She has been married and divorced 5 times. She is not, you know, if your son was married to Aunt Molly, there is a high likelihood that your son is losing half to Aunt Molly. I have crazy Aunt Molly in my family, unfortunately. And your template will does not tell you what can or cannot happen if you say, okay, I'm leaving everything to my son with no protections.
So I've got a question here. So, Lisa, a couple comes to you, you do this estate planning, and then let's say in this case, they would hand it over to John to draw up a trust.
Oh,
Okay?
she draws it up.
Oh, she draws it.
I
You
work,
administer, yeah.
I administer.
Oh, you're just administrator.
I'm just an administrator.
Okay, so I guess this goes to Lisa. So a year or two after we draw up a estate planning trust, oh, I want to change this or that. I'm gonna split, you know, some differences between the kids. Is there a charge for that? Can we get one change a year for free? How do you work that?
So,
I like this.
when we draw up your trust, it just depends on what the changes are. We don't offer free amendments, but we do offer advice and guidance and counsel. So, for example, we put your trust together, we try to cover your contingencies, like John mentioned, having second and third backups to your appointed representatives. We try to cover contingencies if something should happen to a beneficiary, where you would want their share to go. And so hypothetically speaking, let's say one of your personal representatives, your successor trustees, passes away. And so you're completely fine with the person who's named as backup. Well, we don't necessarily have to make a change. Or if you've named your son as your beneficiary, he unfortunately predeceases you, but you've named his kids as the backup in the plan already, and you're okay with that. That's how you wanted the plan to go. There's no changes to be made because we try to cover contingencies. But let's say, unfortunately, there's a falling out, and you no longer trust the person you want to be in charge because they've administered mom and dad's estate poorly, and now you want John's company to act as that successor role because you want to take the emotion and the family out, and you want a professional to manage it. Then there would be a charge for the change, and we would tell you what documents needed to be changed.
Okay, as another example, let's say for this one child, instead of leaving them 50,000, you're gonna leave them 100,000. You know, just a simple addition to the documents. Would there be a charge for that?
Yes, it would have to be an amendment because there's formal rules that have to be followed for amendments to go into effect so that they can't be challenged. You know, you don't want to just hand right in there and cross it out, put 50, now 100.
Very
Well,
important,
then,
very
you know,
important.
somebody says, well, did dad really want this change?
Yeah.
Did that son change it? Was it done in conformity with witnesses, notaries, and other formal
So a
requirements?
typical amendment like that has to do with a dollar amount. About how much is that when it's all done with?
It's hard to say because there could, and I don't know your documents, I don't know if there's other strings attached. Let's say hypothetically there's beneficiary trust language, or there's an outright distribution, or it affects some other portion of your plan. And I don't know that without reviewing your documents, but that's typically done in an hourly rate by most attorneys. Some attorneys charge flat fees and say, okay, I'll do this amendment for this dollar amount. Or they'll say, okay, I'll review it and my hourly rate is this, and we're gonna advise on your other potential issues in your plan, and it just depends on what your plan is.
And here's something you don't think about or count on. The trust law and the probate law is all created up in Santa Fe. So whenever they get together, they may hear, oh, there's this great idea over in California, this law that they just passed, and we probably should throw that in now. So there may be, you go in and you have this one little change, but there are certain laws that have actually changed over a period of time that are enacted by the legislature, and those things sometimes have to be included in your new, your updated plan. So we don't think about that. We think, okay, once we've got it in place, we're good. You can, you sleep well at night, but these folks up in Santa Fe, they have other ideas. Let's add this or change this, or one of them was the reproductive material, assisted reproductive material, stored assisted reproductive material. I always get confused.
Yeah, so it's for if you have viable reproductive organs that you'd like to gestational carry out a child who is not yet conceived. They change some timing with that. That may affect either people who have stored reproductive material ahead of time or are currently looking into having a child after, and then somebody passes away, and how that changes, heirs' rights and laws and things like that.
Not as relevant for this group, but generally speaking.
But it's an indication that things change,
That's
and
right.
you might have to expand on what your trust has indicated.
Yeah.
So,
I have a question.
Here's a question.
Yeah, we've got a couple of
Oh,
questions.
Anyway,
No, sorry, you had a question in the back?
Oh, I'm happy to wait, but, so under your, but since you asked,
this is Clarence. He's from UBS, by the way. Clarence.
So under your scenario of the baby brother and the other kid, so say, for example, you have two good kids and one that's a problem. When you write your trust, is there any way to ensure that maybe the two good kids get more sooner, and have a provision for the problem child to maybe have to wait till they're 35 or 50? Can you write the distributions
Yes.
specifically for the kids?
Yes, so you can make your distributions tailored however you see fit, based on your individual scenarios. So, in my scenario, I'm much older than my brother is. So if something were to happen, my mom could say, okay, well, Lisa has financial maturity, she knows what she's doing, I'm gonna provide for an outright distribution. But maybe my brother, who is much younger, less financially sophisticated, we're gonna delay his distribution, and we're gonna say he can't get anything until he's 50. We'll give a third at 50, maybe a third at 55, and then the rest at 60, because we wanna preserve this for retirement.
And so you set up a trust for him.
Correct.
And have somebody as the trustee, and that's called an irrevocable trust. Correct me if I'm
Correct.
wrong. And an irrevocable trust has some very important values. One is an irrevocable trust where someone else is in control of it for your son or daughter or grandchild. It is protected against creditors' claims, and my favorite one, it's protected against predators. And if you don't think your kids or your grandkids, when they get a bunch of money in, are going to attract this third category, if it's in an irrevocable trust with a third-party trustee, they can't get to that money, that predator can't get to it, because I'm in charge of it, or my company is in
And that
charge.
includes divorce, right?
Absolutely. There are a couple of ways that you can get to it. Child support and alimony.
But it has to be court ordered.
It has to be court ordered. So they're pretty locked up for your child, grandchild, family member, friend, whatever, if it's in an irrevocable trust. So that I wanted us to cover that.
But you can change an irrevocable trust while you're still alive, right?
No,
Is that your
irrevocable
It's
trust,
really-
unless there's a court action and you take it back to court for a modification. There's some non-judicial settlement agreements that can tweak minor things, or decanting is another way to make minor adjustments, so you can't fundamentally change the irrevocable trust. A revocable trust is completely changeable during your lifetime.
And your will, if you have the capacity.
So when do you make a decision on having a will or a trust, a revocable trust, or an irrevocable trust? I mean, how do you decide which one you need now? We saw a number of people here who had wills, and that's good. That's the first step, and then there's a number who have trusts. So how do you, what are the triggers that may push you into the need for a trust?
Yeah, so.
And an irrevocable trust?
Privacy, control, whether or not there's potential dispute for litigation, irrevocable versus revocable trust. Normally, where clients are coming to me for these types of questions are really Medicaid concerns and planning and pre-planning for those types of things, because we want to shift control and ownership. Or if you're in, for example, we've got clients who are in highly litigious fields during their life, like doctors, and they're concerned about being sued in their individual capacity, and they work in a highly litigious area during their lifetime, maybe want to move assets into an irrevocable trust so they have asset protection. Those are some of the main focal points for irrevocable versus revocable trust versus wealth.
I want to hear from these two ladies, but this is, I think, relevant. If you are from if you have a blended marriage, if you've been married before and your spouse passes, or you get a divorce and you remarry, but you have children from your first marriage, and then, or your spouse has children from another marriage, and then you have, let's say, you really enjoy life and you have another child together. So you've got what we call a blended family. That is an opportunity for a trust to be established, because a certain type of trust, it's generally called an AB trust. And I hate to use these terms, but I think I learned it from some attorney here in town. At the first spouse to pass away, it kind of splits, and there's a formula and things that happen that kind of say, we want to take care of your kids and her kids and your kids together. There's a trust formula that can actually help with that. So I didn't want to.
So you got your above ground and your below ground trust.
That's the AB
So
part
you
of it.
provide for the living spouse, but you have an irrevocable trust built into that, so that spouse can't cut out your children or you can't cut out theirs, so it protects the blended family. I'm a child of a blended family. My dad's got a special needs son as well, my brother on that side. So there's a lot of creativeness in his plan to make sure that my brother can still receive his state assisted benefits because he's fully disabled. And making sure that anything my dad leaves for him is for his benefit. Nobody else can take it from him. Unfortunately, my brother is very loving and kind and generous, and people will try to take advantage of that. And if they know that he's got this, pocket full of money there that my dad's preserved for him, it is susceptible to those predators that my brother may just think, oh, these are my friends. They're trying to look out for me. They want to care for me. We want to go on this trip together. Even though he's young, he's had some unfortunate circumstances in his life where he thinks people are really there for him, and they're just taking advantage of his situation. And then so I know we've got some questions. There's a lady in the back in the black.
So I wanted to know, what is an average hourly rate for your services?
So my hourly rate is $300 per hour.
Is that pretty typical for estate planners in Albuquerque?
I would say it's pretty average. Some attorneys that I've worked with charge $450 to $500, $600 an hour. Some attorneys charge less because they have less overhead because they're solo practitioners. So just kind of a range.
I have, and my question might have been answered, but if I'm gone and I have children who can still have kids, can you put money in, or can you put something in that if a baby's born after I'm gone, they are added, or?
Yeah, so usually it's called per stirpies. So you say, I'm gonna leave to my son Bob. If Bob predeceases, then I leave to his children per stirpies. So it's any of his lineal descendants that are either adopted legally or are, his reproductive heirs that he has, that you can include.
This is a juicy one along those lines. So I have a brother-in-law up in Santa Fe, and got some money. Dad and mom were very successful in their business, and everything was rocking along okay. His mom got Alzheimer's disease and passed away. Thank you. I knew this was essential. I have you, Fritz. They did what I did. My brother-in-law, they did, and people love this, and some people are opposed to it. They swabbed their mouth and put it in a little test tube thing and sent it off to 23andMe or what's the other one that's big? Ancestry.com. Okay, so he sends it off just wanting to know, what's my background. Well, about 2 months after he submitted it, not literally, but hello, who's there? It was really like call on the phone. I should have gone ring, ring. I'm your stepsister. You don't know about. And all the estate plan is all taken care of. And oopsie, there's somebody else that Dad hadn't talked about. That was from the past. And this particular test, she got online when she did hers and said, oh, I might have a brother, stepbrother, half-brother in New Mexico. And so, oopsie, there went the estate plan, and it did change. Fortunately, there were, I think, 6 siblings. So now we have a 6.5, and they were all in agreement. Dad had to confess. They're all in agreement that she could be added into the estate plan. So it's really a very interesting, enlightening kind of story that is true that I've
Would that
experienced.
be the same if he was gone already?
Good question. So he's passed.
And then
the
they
dad.
find out that this other family exists.
So it's a little bit more complicated than that. In John's scenario, Dad was still alive and was able to acknowledge. If everybody's gone and there's nobody there, it's usually a court process to legitimize the heirs.
Which would be the DNA test and
Mhm.
what's going on.
Yeah.
So my earlier question about wills, so there's a number of people that have wills. Is that going to be enough, or is there a circumstance where you don't even need a will, or you're good enough with a will and you don't need to move to a trust, or what are the advantages of having a trust over a will?
I think it really depends on your personal scenario, whether or not a will is adequate for your situation. Everybody's situation is different. There's not one size fits all estate planning for everybody. We've talked about lots of scenarios. Is there a blended family? Are there concerns about beneficiaries not being able to manage things? Are there concerns about outright distributions versus distributions that should be held in trust? Are we concerned with privacy and making sure things are administered through a trust privately as opposed to court administration? Delays with court process with probate? Are there concerns about, just individual concerns will dictate whether or not a trust is more appropriate or a will. Let's say you've got a married couple, everything's going to spouse, there's no children or there's joint children, and we've had a full open conversation with all of the potential children as far as who's going to be in charge, what the estate consists of, where it's going to go, and as of right now, there's no concerns. Or maybe we're leaving everything to a charitable organization. All of those things have different factors that take into play whether or not a will or a trust is more appropriate.
And one very important thing to remember, just throw this in, if you have a child, an adult child, or if you have a grandchild that is receiving public benefits, let's just take the adult child that's disabled and he's receiving Social Security, disability, and he's receiving Medicaid benefits of some sort. He's on the developmentally disabled waiver, or if you have to be careful if you outright distribute from your plan anything over, believe it or not, $2,000 can kick that person off their public benefits. So that needs some careful, thoughtful planning by your estate planning attorney with you, because you can disqualify them by giving them $2,001. I mean, it's crazy, but that's the way our Medicaid and Social Security rules and regulations are established. So for those, you may not have someone that's disabled, but if you know somebody, let them know I'm going to give my disabled child $500,000. They best put it in the right kind of vehicle that protects those assets. I'm
So-
sorry.
If Santa Fe makes changes, is your original plan grandfathered, or do you have to change with the new changes?
It depends on what the type of change is, honestly. There's a lot of different changes that happen that may or may not affect people's estate plans. So, for example, one of the big changes that the firm I was with at the time sent out, a lot of different letters revolved around the Secure Act and changing IRAs and how that administered. That didn't affect everybody's plan. There's a change to the sunset provision for estate plans. For right now, it's over $13 million per person, scheduled to come back down at the end of 2025
Your estate exemption tax.
to $5 million plus inflation. That may not affect everybody, but these are plans that go into effect based on federal and state laws. That's why it's really good to have your individual plan reviewed with an attorney to advise whether or not that change affected
So
you.
you would have to,
Maybe.
if it applies to you.
I'm just gonna say that, look at the taxes too, because there are different tax rates for trust versus individuals.
Very
In fact,
important.
it's double in trust unless they.
Are you a CPA?
I'm retired.
Aha.
So, so the tax,
It's like
the state
37
tax, you mean?
No, income taxes that are generated for trusts are different than income taxes
Okay,
that are
gotcha.
generated for
Higher.
people.
Higher.
And there's differences between if it's a grantor trust, an irrevocable trust, whether it has see-through language. So there's all sorts of different rules that apply. And just to give you a really dry, shallow example, if I personally, in my individual capacity, make $1,000 worth of taxable income, it's going to be taxed at my individual hypothetical rate of 15%. If I have an irrevocable trust that has $1,000 in income, that's taxed at 37.5%. But then there's also all sorts of different trusts have certain things that can be deductible versus personal expenses that are deductible that don't always apply one to the other. So there's lots of different involvements.
That's why we like to have, I love this word, collaboration. So when we're meeting with our client, after their plan is established, I want the CPA involved. I want the investment advisor that's handling your finances. I want them involved. I want us all to be looking at, talking about the same scenario so that everyone's aware of what's going on. And is there a better way to do something? That's why we only engage CPAs for trust tax preparation. And so if you're an enrolled agent, fantastic. You have served a great purpose. If you work, volunteer for a nonprofit to help with people's taxes, fantastic. But if you have a trust, then we involve a CPA in that preparation.
So most of our clients have, and I work with Lynn Johnson, by the way. This is my wife back here, Lynn Johnson. I work with the Lynn Johnson Group, and most of our clients have named their kids as executors or personal representatives. And one of Lynn's clients who recently ran into some real difficulties with that because the executor started to make decisions on their own. And so, what's the advice, or how many? First of all, how many people, generally speaking, have named their kids as executors, and is that a wise thing to do? Or, I know the alternative obviously we have is John, but how many people actually do that, and how does it always work? Does it normally work out for those people?
So again, I don't think estate planning is a one size fits all. Somebody could have a very financially mature child and is able to make those decisions. For example, my husband's family, him and his sister are both named as co-personal representatives, co-trustees, because they're both attorneys. The other two, one's a vet, one's IT something. I don't really know what my brother-in-law does. He does something with computers. So that decision was personal to my in-laws based on that particular family circumstance. The family gets along, the sister, the brother, the siblings have all open dialogue, everything's on the table, what assets there are. Some families are a little bit more reserved and they don't like to divulge all of that information. Some people say, okay, well, I'm gonna name my kids, I'm gonna do it in age order because I think that's fair. Well, what if age order, you've got a substance abuse problem, maybe a child who has had bankruptcy, and then the last one is not financially mature or doesn't make decisions? Well, in that scenario, it's not appropriate to name your kids. Or maybe they don't get along and they're still mad that you gave child number one the last piece of bubble gum on the family trip, and they're holding on to that. I've seen, and I'm sure John has seen, crazy stories where people are upset about things because of family issues in the past that they may not express to their parents, or parents think, oh yeah, my kids get along great, they always show up together, they always get along, but in the back end, they're always fighting and bickering over text messages and Facebook and social media, and parents don't see that part.
And don't think the dynamic just should go haywire with your children. Some of them are married, or may not be married, they may have a partner, and
Have been
it
married.
could be, yeah, and it could be, I've had this example, I've seen it personally, it's the in-law, it's the son's wife that is, I call it whispering in the ear of her husband, your brother isn't doing it right. You're getting cheated. The pot stirrer. So you have to kind of factor a lot of things in that you may not think about. That, oh, my kids get along wonderfully. Well, is there potential? You really don't know, because money does weird things to shall we say, all of us. It just does. And it's not just the money. It's my dad would, he'd probably get a grin when I said that it's the stuff sometimes that creates more problems with family dynamics than the money does.
Sentimentality.
Sentimentality involved, right? The bubble gum you didn't get when you were in the trip. So you've got to carefully think about all that and how all that dynamic. If you have a advertisement again, if you have a corporate fiduciary handling it, all the kids can get mad at me. All the kids can sue me. I've got insurance. I've got, I handle. There's a law, a trust law and probate law that says I can't. I have to be impartial toward all of your kids. I can't treat one better than the other. I can't buddy up to one. I've got to handle each one exactly the same. Communicate with them exactly the same. I can't show partiality. That gets a little tough with your own children.
Especially if one's the personal representative and a beneficiary.
Right. There's complicated, conflictual things that can happen there.
And do you take that on a case-by-case basis? Or is there a general recommendation you make as having a child who's the executor who's also beneficiary?
Case by case basis, what is the assets made up of? Where things can get tricky. Let's say you've got two kids, you name one as the personal representative, and you say we're going to split the estate 50-50. But then that person's local, so then they maybe move in with you to help you take care of things throughout your lifetime when things get more difficult. And then they say, well, I've lived in this house. There's my stuff in here too. This is also my, my home. How do we deal with limited assets when this person is also saying that they have a beneficial interest that you may not have intended when you put your original plan together? There's just a lot of different scenarios that can come into play.
Okay, so I'm going to switch gears just a sec. I wanted to switch gears just a little bit, and you talked about earlier about the documents you might have, the health directive, what about like insurance and some of the financial things that you want to do, set up for long-term care? Is that would you say that's part of an estate plan? I mean, I know we have Spencer Wallen here who does reverse mortgages, so if you wanted to set up your house as a source of income, that would, while you're still alive, where you don't have to make payments and you can actually take equity out of your house. That's one avenue that can help you pay for long-term care insurance, which then would allow you to have carers when you had an accident and you needed people. So I mean, would you say that's all part of an estate plan?
Yeah, so like John mentioned, it's collaboration. We like to take a holistic approach. We talk to your CPA, we talk to your financial advisor, we talk to your nominated personal representative and trustee, if appropriate, if you've given us permission to talk to all these various people, because we want to keep your information secure under attorney-client privilege. But by putting together a holistic plan, we can make sure your tax plan matches up with your estate plan, matches up with your financial plan. Because if your plans aren't talking to each other, then what's the point in having a plan? You can say in your trust, and you can draft you a beautifully drafted trust that says, I want my entire estate to go to the Lost Puppies and Kitties Foundation because I care so dearly about animals. But then you've subsequently told your financial advisor, I want everything to go to nonprofit to help the homeless and the needy. Well, now our plans don't match up, and depending on what your assets are, there may be tax advantages to doing direct beneficiary designations versus doing things in a plan. And if we haven't talked to your CPA about the types of taxes that can be triggered, we've just undid everything, and so we want to make sure all of your plan talks together.
And while we're on long-term care insurance, I'm one of the biggest proponents of long-term care insurance if it's in that, and Clarence, I know you didn't come for business reasons, but an investment advisor should help you understand when it makes sense and kind of when it may not make sense to have long-term care insurance. So it can be, if you're in that right spot, age-wise and health-wise, it can be extremely important, because what I see from my perspective is people will accumulate wealth over time, and then Kim back there knows she pays the bills for the home care company that comes in, and you start out with a little bit of help, and then as something progresses, an illness or your dementia or whatever, by the way, our perspective is we want you staying in your home as long as you possibly can. You're safer, you're more comfortable, you have a more fulfilling life if you can stay in your comfortable surroundings. Now you may need to downsize, and then you talk to Fritz. But see, I threw that up, but we want you there. As long as your money can keep you where you excel in life, where you exceed our expectations. So long-term care insurance can help buffer that expensive in-home care that people will spend at some point, some people.
What if you do not have anybody to leave anything to?
What if you don't have anybody to leave anything to? Very good question. I'm gonna let Lisa answer that.
So if you're in the situation where you don't have family, friends, or other people that you have or don't want to leave money to, there's always charitable organizations, there's causes, there's nonprofits, there's foundations, there's donor advised funds where you can give to a specific cause or group and have a financial institution manage it for a certain purpose. There's a variety of different organizations that you may choose to leave to instead. The default, if you don't have a plan in place, you haven't put anything together, you pass away and it passes by intestate succession, first goes down your lineal lines, then up to your parents, siblings, down to their children, then goes back up to grandparents, aunts, uncles, down to the cousins, etc. And then eventually it sheets to the state and goes to the unclaimed property division of the state where you are a resident, which is not usually where people want things to go.
Clarence.
So,
Clarence is the financial advisor. John was just.
Dave, so I have a question for you. So, is it true that if you have a will but you don't have a trust, and you die, your assets go to probate, yes?
If you have just a will alone and nothing else.
And is probate an expensive or long process?
It can be. Anytime you get the courts involved, it makes things much more difficult. Sometimes you have, I'll give you an example there. The judges sit on a bench and not all the judges are estate judges or probate judges. So I've got one case where I am still waiting 7 weeks later for a court hearing to appoint a personal representative in an uncontested matter where everybody's agreed to who's going to be the personal representative, and the family is right now paying all the bills and expenses until the person gets appointed.
So typically under some kind of circumstance like that, if I have, just a standard estate, and there's no such thing as a standard estate, but let's say I have an estate, I've got brokerage accounts, have a couple houses, whatnot. It all gets directed to whomever. And then it goes to the probate court to decide how that's distributed. That's also made public record, yes. Whereas a trust, you have that privacy. But wouldn't you say that on the whole, if you have an estate and it goes through probate, that is more expensive than going through and just getting a trust done to begin with and just paying the $2,500 or $1,000 from it's going to cost your estate more than $1,000 or $2,500 to settle a probate rather than having everything in trust. Is that right?
In my experience, yes. So usually trusts are more expensive at the front end to purchase, and then there's work on the front end to fund it, retitling your assets into this entity. It's like a bucket, so you move everything into it to hold. Then when you pass away, you become incapacitated, your successor administers your plan. Usually setting that up on the front end is a little bit more expensive, but in my experience, even though a will is more cost effective at the front end because it's cheaper to do a will at the front end, it's usually more expensive on the back end to administer, going through probate, going through the court process, administering it, having all of that set up, whereas a successor trustee, usually the triggering event is death, then the successor trustee steps into your shoes. Once you get that death certificate, you're off to their races. You can go to the financial institution, start retitling things over into your control as the successor. But with a probate, you not only have to wait for the death certificate, you have to wait to be appointed by the court. And then there's certain timelines and things that go into place. Even though the application gets accepted, maybe the district court judge accepts your application, but it's sitting on the order for 2, 3, 4 weeks. Now the order's entered. Okay, great, now you've got an order. 4, 5, 6, 7 weeks later, you get your letters of testamentary issued. Just depends on how heavy the caseload is for the judge, who the judge is. Some judges turn things around very quickly, and I'm happy when I see their name on my docket. Some judges don't, and I just wait and wait and wait, and I keep calling their JAs, and eventually they get pestered with me enough that they issue my order.
And then there's putting publication out there for creditors and to take, it's just like, it can be a long, extended process.
I may want to just make a little distinction between a professional fiduciary and somebody in the family, because fiduciaries who do it for a living are making a buck every year. They're making money to manage that account.
Maybe, but I'll give you an example that I just ran into not too long ago. It was a smaller estate. All 4 children were the same mom, same dad, no blended family issue. They thought they had a simple estate plan. Dad was going to name one person as the personal representative because they lived here locally. The other people lived overseas and in other states, so in his head it made sense to name this person. He wasn't aware that the 4 siblings really had disgruntled feelings towards each other that they just didn't express to Dad during their lifetime because they were all family, they all got along while Dad was alive, but as soon as Dad passed, everything got let out from everything that they were mad about since they were 2. It was a very unpleasant situation for the person who was nominated as personal representative, just trying to do what they needed to do to administer dad's estate. Unfortunately, the estate wasn't very large. It consisted of home and collectible items that were very hard to market because they had value to dad, and eventually they were able to generate some money for the estate, but it took a really long time because these items were not things that there were ready, able, willing buyers today that were going to buy this piece of item. So it took over a year and a half to administer, and then because of other situations, the house was not in a great neighborhood. They weren't able to get insurance on the house because it was unoccupied. There was a break-in, vandalism, some of those items were taken, and this estate and this person didn't have insurance, unlike a fiduciary that would have been able to reimburse the estate for that had that situation happen under a professional control. And so police report was filed, but sometimes being the areas we're in, sometimes that's all that gets done is a report's filed, and these items that could have, and it's all speculative, we don't know what they were valued at, but there's no insurance claim to make that against. If these items aren't recovered in a pawn store or, in the Arroyo or somewhere else, the estate's out of luck. And the sibling who unfortunately had to bear the burden of trying to administer this and get the most money for the estate for that was very small, and that dad didn't think a professional was going to give a financial value to the estate, ended up detrimenting the estate. The relationships were already bad, and now there's no recourse other than just what's left is what can be distributed because it got stolen and vandalized.
So I wanted to ask this. So John, if you're the person in charge of a person's trust and they have a house that sits vacant for 6 months, and somebody comes in and does a whole bunch of damage, your company carries insurance to make that right?
We have the authority to insure that property, and it is our fiduciary duty to make sure it's insured. So
But our beneficiaries would pay for that. But you'd make sure
the
it's in
estate,
effect.
yes, the estate pays for
Okay.
the insurance. That's good point. So the first time I heard this expression was Saturday when Steve Stucker was on the television, and somebody referred to him as the balloonatic. I've been here 16 years, I never heard him called a balloonatic. But when Steve Stucker, now he's retired, but I always remember when Steve Stucker comes on the air and he's doing the weather and he says, make sure your pets are coming in, make sure your plants are covered. The trustee, my antennas start to tingle thinking, is there a vacant house in Albuquerque that we are trustee for, and will the heat be turned on? Because, oh boy, that pipe breaks, and then you get flooding, and then you get black mold, and it is drywall up to 4 feet, 5 feet. They cut it out, they got to eradicate. Very expensive problem for the estate, but the professional trustee and private trustees, they may or may not have experience with that, knowing that when Steve says it's going to freeze, you better make sure that house that no one's living in has got the heat on. So those are my real life examples of understanding the value of a corporate trustee as opposed to someone that this is their, one time they've done this kind of thing. So we have a deep bench again of people that sit around a table and discuss issues, problems, solutions that an individual may not have that expertise. We're close there.
So I think we have time for another question or two, and go ahead.
Really quick, and I think I already forgot it. You mentioned dual personal representatives. Do you really think that's a good idea?
It depends on every situation. Sometimes it's not a good idea because there's a conflict. What I've run into a lot is that we name co-personal representatives and financial institutions says, great, you've given them independent authority, but we don't want the liability, so I'm not letting any checks go unsigned without both signatures. I'm not letting any account applications go unless both people have signed it, and it becomes an administrative nightmare. Sometimes it makes sense because maybe it's a blended family situation and you want a representative from each family to protect the interests of the other families, and we don't have a professional serving in that capacity. So it really just depends on case by case scenario. My general inclination when somebody first says they want co-personal representatives because they want to treat all their kids the same way, and that is the only reason, because they don't want hurt feelings. Usually, no, this is not a good idea, and I say these are the reasons why it's not a good idea. But if there's certain circumstances where it makes sense, maybe.
Yeah, we had one client who had cope because they didn't trust that one would be able to do it, and they thought that both would facilitate it better, but now you've got two people writing checks, it's that kind of thing. It
And
gets
signing
complicated.
closing documents
Signing closing
and
documents,
sending
yeah.
documents back and forth. Usually I joke and I say, which one of your kids do you like the least? Because they're gonna have to do all the work and not really get any more bang for their buck, and they're gonna, have a lot of family issues that they're gonna have to deal with from the others thinking that they're not doing it timely, they're not doing it right. That depending on your state and how much stuff you have, it can be a full-time job. What if your children or the people you've named are still working full-time? Do they have the time, capacity, effort to put into making sure your estate is administered? What is their relationship with the other people? There's a lot to go into.
Should you ask before you name them? Should you ask them if they are willing?
I generally recommend it because sometimes, I've had somebody come to me and say, I had no idea, now I gotta deal with this, now what? I highly encourage having an open dialogue if it's appropriate for your family. Let them know, what are your assets? Where are they located? What's important? Having a discussion with the entire family, this is who I've nominated and why, this is where I want stuff to go. In the little green folders, there's estate materials. These are not wills, these are not trusts, these are not legally binding documents. They're just to help you think about things that are not always included in a traditional estate plan. What to do with personal property? Who's gonna take care of pets? Do any of your pets have issues? I'm guardian for my sister's pets, not that I don't have 8, but she's also got 3 large dogs that have autoimmune issues. They're all rescues, they've got different dietary restrictions and other things like that. I know this, my sister's boyfriend doesn't know this, and he's, boots on the ground if something happens to her in Phoenix, so he's gonna be calling me to say, what do I do with Jameson? He's going nuts. So things like that. Where do you want the personal property to go? My Grammy told me that there's this super ugly green pot that she has in front of her door, and by no means is it to go to an estate sale because it is super valuable. She brought it from Germany from her parents. I don't really know, but now me and my sister know that we're going to be cursed and my Grammy's going to come after us if we do something with this pot. We didn't know that. We just wanted the recipe cards and the sugar drop cookie recipe. So things like that. These are just ancillary things to help you think about other things inside of your estate plan.
So as you leave, you're welcome to pick up the materials here in the green folder from Sutton Fairground and from Lisa, and then also from John. Let's give our guests, our panelists, a and please don't forget to fill out the evaluation on the last page. We'd love to get your input, and thank you for coming.
Thank you for having me.